One is about section one. Section one is history of data protection law in Europe. So when I say history of data protection law, uh, can someone send the link again? Okay, I know this is gonna happen today. Yeah, I have it handy. You should be able to see it now. All right. Yeah. So the first section is about history of data protection. So there are three major sections in the CIPP curriculum. The first is history of data protection. Second is the GDPR section itself. And the third is the application of GDPR. So we have completed section 2 and section 3. One chapter is left in section 3. We will see at the last. We are the section 1, which is introduction to European data protection law. When I say this section is more of history, the reason to it, right, because the chapter 1 and chapter 2 is predominantly deals with what are the significant historical event that happened and how it has shaped the European data protection law. And there are different European Union institutions which plays a different role, an important role when it comes to data privacy. We'll all be discussing on the same. Since it's a lot of history topics which we are going to discuss, I'm not going to go into the depth. I don't want to make you feel very bored, so I'll limit as much as possible. But at the same time, I'll try to provide as much important information that can be useful for you in the exam. All right. So, so the first chapter is introduction to the European detection law, and the maximum question is one. You will get a very minimum question in this. All right. And so we will, in this chapter, you will see rationale for data protection law. When I say rationale, what triggered European data protection law? So there was a rise in the internet, and even before that, the large processing activity started happening between banks, and banks started creating automated data banks. So they were storing a lot of information about users. All these things are increase in ICT. All these things were important reasons for having a data protection. And the history of European data protection, or even any data protection law in the world, it starts with the first important event, which is the Second World War, right? So in Second World War, we had ethnic cleansing, which happened, which targeted a uh, particular tribe. So not tribe, actually, particular religion. And so because of that, after the Second World War, so the United Nations, which was formed, it came up with the first draft declaration on fundamental human rights and freedom. So it is called as UDHR. So it was created in 1948, which is called Universal Declaration of Human Rights. Okay. So it came up with two important requirements, and those two important requirements are even today, those are actually considered as the foundation element of data privacy, right? So if we go even for all the data privacy law up to GDPR or any other law, so it all has the basis starting from the 1948 UDHR. Okay, so UDHR comes up with two important requirements. The first, the first requirement is about uh, right to freedom of expression and right to private life. Okay, so these two are very important requirements which has been still resonated in every law that comes around the world. And one important requirement is that both the requirements are not actually absolute rights. When I say it's not absolute right, because my freedom of expression should not affect your uh, right to private life or your freedom of expression as well, right? So that is something which we need to be absolutely sure of. Right to private and family life is from Article 12, and right to freedom of expression is Article 19. So for this particular topics in exam, these particular topics are very important from the exam. What are the two important rights that came up in UDHR, which is right to private and family life, right to freedom of expression. And so both these rights are not absolute. It needs to be balanced, right? One right cannot be absolute for any person, and it has to be looked in from the context. All right. So the next what happened is the same has been adopted in the European Union circles, which is called European Convention of Human Rights, which is called ECHR. It got adopted in 1950. So they adopted the same two articles and they echoed the requirement. And this can be enforced by a special court which was created, which is called European Court of Human Rights. Okay, so when it comes to the second important significant event, you need to know UDHR led to the creation of ECHR, which is European Convention on Human Rights. Okay, it came in 1950. It echoed the same two articles, which is right to private life and family life, and right to freedom of expression. And and also there is a court which was created, which is called European Court of Human Rights. And so the requirements of ECHR are fulfilled via the ECTHR, which is European Court of Human Rights. All right. So this is the first two significant event. And then we go to 1980. 1980 OECD guidelines. So OECD guideline is very important institution in data privacy. The reason is OECD, first of all, stands for Organization of Economic Cooperation and Development. So they issued a guideline, okay, which is called OECD 1980 guidelines. And it actually sets a framework for any country which doesn't have a data privacy law. And just to facilitate the free transfer of data between countries, certain countries had data privacy laws, many countries never had data privacy law. We are speaking about 1980, right? So what happened is OECD released this guidelines, and whichever country didn't had a law, they can adopt this and keep it as a framework, right? The only difference is this is a guideline, so it is not a binding requirement, it's a guideline. And the purpose of that is to govern trans-border data flow and create harmonization of data protection law between the countries, right? So that is the basis for legislation in countries that do not have any data protection laws, right? Even the principles which are there in 1980 OECD guidelines, 70 to 80% of the are the same principle what you will see till today in GDPR, right? So that's a very important milestone in when it comes to the data protection laws in the world. 1980 OECD principle, almost we have, I think, around 8 principles were there. 6 principles are almost the same what you will see in GDPR. Yes, there are a couple of new principles added, but the core crux almost remained the same, right? So after 1980, we had the next important milestone, which is 1981. So the Europe came up by the influence of 1980 OECD guideline. They came up with the first binding data protection law, which is called Convention 108. Okay. So, sorry, first binding instrument. Okay. So, till date, we celebrate something called Data Privacy Day, correct? So, the Data Privacy Day is celebrated based on this particular event, which is the Convention 108. Convention 108 is the first binding instrument in the data protection law space, right? So, what it mandated is that whoever country is who are coming part of this convention 108, they need to ratify the requirements which has been proposed, and so then those countries will be subjected to the convention 108. All right, this is something which is very important for you to know. I'm not going to speak on 1984 and 1993. These are not that significant event. In 1995, the predecessor of GDPR, which is called as 1995 directive, came into force. So 1995 directive is a very significant landmark when it comes to the European data protection law. And majority of whatever we see today in GDPR is from 1995 directive. And yes, of course, there are some changes, but 70% or 75% of whatever we see in GDPR is already from the 1995 directive. And the drawbacks of the directive was fulfilled in 2016 when GDPR was enacted. So what were the drawbacks? Basically, it came in the form of a directive. So what is the difference between a directive and a regulation is a very common question in the exam. So when we say in the European Union space, directive means it is a binding instrument which is created by the European Union, but the implementation form is left to the countries to decide, which is the member states. So the member state will decide how to ratify that requirement into their own laws, and they will decide on how to implement it. Okay. Whereas when we say regulation, regulation is enacted at EU level and doesn't require any form of implementation in the member state. It is directly enforceable, right? So why this change happened? So when the 1995 directive came, there was a disparity in terms of how countries adopted. Certain country adopted it in a very stringent way. Some countries kept it very diluted way. So this created a disharmony for companies which are operating across European Union, and so that was a preliminary reason when the 1995 directive was replaced with the 2016, although then there were some changes which were required. So for example, in the 1995 directive, one important drawback was that every institution whichever doing any processing activity, they need to inform and register the processing activity. Just imagine the humongous workload overhead cost which would have been there to notify each and every processing activity to the supervisory authority. Such requirements were removed, and certain new data subject rights were added, penalties were increased, accountability framework were introduced. So these are some of the significant changes that happened from 1995 directive to the 2016 GDPR, right? So in between, we had one another important event, which is called as e-privacy directive. So e-privacy directive, among the other data protection law, we also have LEDP, which is law enforcement directive, and we also have storage retention directive, I guess. So some of these directives are very significant from the exam perspective also. You should know what role they play. Example, e-privacy directive and GDPR have a common ground, a touch point, and the certain processing activity can trigger both the material scope of GDPR as well as e-privacy directive, which is, I think in the previous session, I gave you some example, which is the classical case of cookies, right? Whenever you are using cookies, you trigger both GDPR and e-privacy directive. So in this case, there is a mechanism which has already been established, which is called lex specialis and lex generalis. So the specific law, which is for a specific criteria, will take the precedence, which is the e-privacy directive. Many of the people are still not aware about this in the market. They say GDPR is the everything and anything for data privacy in European Union, but when it comes to cookies, generally the e-privacy directive is what takes the precedence, and the requirement has to be fulfilled from that perspective. And GDPR will be the lex generalis, which means all other general requirements will be derived from GDPR. All right. So this is something very, very important, and you should be aware of from the exam perspective. And what else? So there is an updated version of e-privacy directive, which is be replaced by e-privacy regulation. E-privacy regulation will be actually. Can you explain a bit about e-commerce directive? E-commerce directive, when I prepared for the exam also, I just studied two lines and just kept it in my notes, but I don't think so. No one has ever tested e-commerce directive, and it's not important from the exam perspective as well. Okay. So if you want, I can actually just think about it. Uh, So I think it is for whenever we are doing any business transaction in the European Union using the ICTs, right? Information Social Security Services. You have this directive will be applicable in that case. There are criteria which triggers this e-commerce directive, and e-commerce directive again, not much. I have personally not seen any of my candidates have been tested specifically on e-commerce directive. So don't worry too much. Yes, I know that has been mentioned part of the book, but don't worry. You don't need to go to the depth because all of them are separate directives. How much you're gonna go into knowing each of them, right? So if you want, you can just understand what it has from the data privacy perspective. To be honest, I actually don't remember because I generally don't focus on that particular topic because it's not usually tested to that extent, right? So maybe you can chat with me separately. I'll look at my previous notes and come back to you if I can help you with any of the content which I've created before. All right. I'm being honest with you. I don't remember because there are so many things which are there when it comes to this European data protection law. All of them are separate topics on their own, right? So it's better we need to prioritize what is important from the exam. We might very well get lost in the section one, so don't spend too much time into this. Uh, Second, which is law enforcement directive, LEDP is what we call. So LEDP is very important from one important perspective is that it regulates the law enforcement agencies in when it comes to processing personal data. So processing of personal data by law enforcement agencies generally happen when in terms of uh, the purpose to prevent crime, investigation, detection, and prosecution of criminal offenses, right? So this particular directive will control on the free movement of such data, and so it helps to harmonize the rules in place across the member state and to protect the citizens' fundamental rights. So this is something which is important, which you need to be aware from the exam perspective. The next is data retention directive, very important topic because it simply has signified important decision taken. So data retention directive was created in 2006, and it was created with intention to ensure availability of traffic and location data for the law enforcement agencies for serious crime and anti-terrorism purposes. All right. So, but in 2014, the Court of Justice of European Union ruled that this directive was invalid on the grounds that it was disproportionate in scope and incompatible with the rights of privacy and the fundamental Charter of Fundamental Rights. So very important exam question, which is usually tested. So the Court of Justice of European Union is like the Supreme Court. So generally, people whoever feels that any of these laws, directives challenges their fundamental rights, which has been enshrined through different laws, which we will see it in upcoming. I don't know, we will see, will not see, but in today's session. But if you join my session, we will go in the depth. For example, what is Charter of Fundamental Rights and other things, Treaty of Lisbon, those things we will discuss in detail. So these rights have been enshrined to all the data subjects in the European Union, sorry, citizen to the European Union. In that case, so they challenge when there is a new directive which actually impacts their fundamental rights. So in those cases, the data retention directive was invalidated by the Court of Justice of European Union, which is very important. All right. So we'll move on to the chapter 2, which is about the European Union institutions. So you get a minimum one question for sure in this. Is it residents of European Union or citizens? I think this is GDPR is for the residents. And but if you see the other laws, you need to look at the scope of it. I think it may look for citizens or residents. I'm actually not into the depth of European laws apart from GDPR. So as a legal person, sorry, if you're a legal person, you need to see it. Otherwise, you just Google it in terms of scope of such laws, whether it is for all the residents or it is only for the citizens of European Union. All right. And also, I don't work on European market, so I'm actually not that familiar in terms of the other laws applicability except GDPR. All right. So let's start with European Union institutions. So European Union institutions uh, are the foundation our foundation for the data privacy laws, whichever we see in the future. They all of them had some important roles to play. So when it comes to European institutions, let me go to the previous slide. This is better slide in terms of explaining it. Then I'll go the interplay between them. So we have around six important institutions which we need to know what are they and how are they playing role when it comes to European Union decision making and what role they have in terms of data privacy. So the first institution is, I generally give this anecdote for people who are in India. we have something called Lok Sabha and Rajya Sabha. So I think we have participants outside of India as well. So just a common terminology is like in every country which is a democracy. So you will have people elected members, right? So that is what we call it as parliament. So the same concept is in Europe, which is called European Parliament. The members, whoever are there in the European Parliament, are directly elected by the European Union citizens, right? And so there is a concept which is for in terms of a federal model. What I would say is when we have the representatives are chosen, right, by the elected members. So we call this as Rajya Sabha. So the Rajya Sabha members are actually represents the Council of Europe. Okay, so Council of Europe is in terms of but here the Council of Europe is one of the very powerful body. So we call it as Council of Ministers or Council of Europe or just the Council. Okay. So what is about this council? And so they along with the Parliament have some very important powers when it comes to the European Union. Okay. So they are vested with co-legislating power with the Parliament. They create, they exercise the budgetary function, and they carry out the policy making and coordinating function, right? So they are one of the very powerful bodies, and every member state, we have 27 member state, each of them will represent one minister to be part of this particular council, right? So this council is very important when it comes to decision making. And so what they do in practice, so they actually can amend the proposal before adoption. They actually conclude the international agreements negotiated by the Commission, and so they have some very important role. For any law has to come into force, there are three ways that can be done. One is consent procedure, second is consultation procedure, third is ordinary procedure. I'm not going to go into the depth of all the three. Basically, in terms of consent, you need just the consent of the Parliament, and consultation, you just take the opinion, and ordinary procedure, you need both permission from the Parliament as well as the Council to enact any laws. So moving to the Parliament, as I said, is directly elected representative. It's a voice of the people, and uh, they have legislative role, but they can't propose new legislation. So the proposal or the people who actually do the groundwork is all done by the European Commission. So what Parliament does is basically they actually invite the Commission to submit a proposal or amend an existing policy, or they actually share they share the powers with the council in terms of key decision making, right? So they ensure the voices of the people are heard, and especially on some key important decisions, like even the GDPR. There was a lot of positive debates that happened in the Parliament in shaping the GDPR, right? So it has usual 5 years terms, and it has 751 members, and each member state has a representation based on I think minimum of 6 and maximum 96 people representation for each member state, right? And so that's about Parliament. And third is Commission. This is a very important topic from the exam. The role of Commission is very important. The Commission actually plays some very important decision making. So it is called as the executive arm. Okay, and so they have the power to initiate legislation, and they are also called as guardian of treaties. Another important point from exam perspective. So why they are called guardian of treaties? So the laws whichever is getting enacted, they are the supervisory role, right? For example, if GDPR is there, one member state is not following GDPR requirement, or one particular law is often broken by a particular country, right? So in this case, European Commission can pull up these countries in front of the Court of Justice, right? So they have powers to start investigation, even pull up a country before the Court of Justice. It happened with UK. European Commission pulled UK in terms of requirement of I think from the 1995 directive perspective, something happened like that. So European Commission is definitely the important operating arm when it comes to the decision making. And so if you remember the adequacy decision which we discussed when it comes to international data transfer, so all those important decision making is done by the commission. So commission periodically, I think that there is a 3-year cycle for all the adequacy decision. So periodically monitor them, and they can add more countries, remove countries. So hopefully we'll see India should come part of the adequacy decision with the DPDP bill if it comes into live. Okay. So and European Commission is responsible in terms of enacting the 1995 directive GDPR. As I said, they are the ones which they come up with developing these directives and regulations. All right. So every country, 27 member state, will appoint one commissioner, and each of the commissioner together will select their head of European Commission. All right. That is the way it is done. So European Council. What is European Council? European Council and Council of Europe is often confused by many candidates. So European Council is a strategic body. Okay. So European Council uh, is headed by the state head of states. For example, there are 27 member states. All the prime ministers of the countries usually are part of the European Council. So they meet twice in a year. They come to decide on the strategic direction for the European Union. It's very simple. So though they are not actively into the other decision making like what we see in Council of Europe, but they are the strategic body. They decide on the direction and course, okay, in terms of European Union. So in terms of European Council, you need to just understand they don't have any legislative power. It's again something which is usually tested in the exam. European Court of Justice, or European, we call it as, we can just remember that as that's a Supreme Court of European Union. So, so the very important body, it has a legislative power. So they make decision on the issues of EU law, enforce EU decisions, and when either Commission or individual takes a case against a member state. So if you remember the Max Schrems case, which invalidated the Safe Harbor and Privacy Shield, both these judgments were given by the Court of Justice of European Union. The same with the Data Retention Directive as well, right? So that's again a very important and significant judgments. So again, when it comes to the GDPR CIPP course, you also need to know some of the landmark judgments which came through the Court of Justice of European Union as well as the Court of Human Rights, because these judgments actually set precedents of how certain clauses should be interpreted and how it should be actually implemented. Some of the landmark Veltimo cases there. I think there are 7 to 8 important cases. I usually share the important crux of them during my sessions. And so these judgments actually set a clarity. For example, the law says establishment. What constitutes an establishment is generally given by the judgment. So there are 4 to 5 different criterias which highlights what constitutes a establishment. So you need to have uh, specific you need to have human resource. Sometimes you don't need to even be registered through the Companies Act or something like that. And specific, for example, the extraterritorial scope as well. So what constitutes an intentional processing, right? So that also came because of the Court of Justice of European Union. They gave again 3 4 pointers in terms of do you have a euro currency in the transactions? Do you specifically target them with the European Union testimonials? Do you have a website specifically designed for the European Union citizen? Is the website domain registered in the European Union? So these are some of the elements which we need to consider for arriving at whether it is a intentional processing or not. So that's the reason we should closely follow when it comes to some of the landmark judgments coming from the Court of Justice. All right. So I do share with the Google Spain, which is the right to be forgotten, was the first significant landmark right to be forgotten case, right? Veltimo case, Max Krem's case. These are some of the landmark judgments we will be discussing on a regular sessions. Moving on to the European Court of Human Rights. So European Court of Human Rights has this jurisdiction based on ECHR, European Convention of Human Rights, and also it deals with the Charter of Fundamental Rights as well. So whenever there are any human rights violation, it is referred to the European Court of Human Rights, and there are also some landmark judgments regarding European Court of Human Rights. I'm not going to go into the depth of them. So the enforcement burden of European Court of Human Rights is generally taken by the Council of Europe and the Commission. And what you need to remember from the exam perspective is that European Court of Justice, European Court of Human Rights is actually not a European Union institution. That's something which is quite important for you to know. And in terms of enforcement, they always, it's a binding, whatever they give judgment are binding, but enforcement cannot be done. So they depend on the Council of Europe and the Commission to enforce it. All right. None of the links are working. It's quite surprising for me. I think others were able to access it. So kindly let me know. So this is a sort of interplay between the Commission, Parliament, and the Council. So the Parliament actually supervises the Commission, and the members are appointed by the Council. All right. So that is the important sort of a make a checker concept, I would say. So they ensure Parliament oversees the Commission actions, and it is appointed by the Council of Ministers. So both these bodies have co-legislative power. So they propose legislation and budget. They also have co-decision powers as well. Uh, so this is all about your European Union institutions. So this chapter, I think we already discussed to an extent what are the different legislative framework which exist within the European Union. The Council of European Convention, which is Convention 108, which is the first legally binding instrument. So you get minimum 3 to maximum 7 questions. So then European Data Protection Directive, which is called 1995 Directive, which is the predecessor of GDPR. And in this case, we need to know the difference between directive and regulation and what are the key changes that came from directive and regulation. Uh, and in terms of directive on electronic commerce, someone asked this question. I've seen very less question comes out of it. European data retention regime. We discuss about the European data retention directive getting invalidated by the Court of Justice of European Union. And you should know what exactly was the reason from the exam perspective. And finally, the GDPR. And GDPR came in 2016. What are the effective changes that came from the previous version? All right. So this is something which you be aware of. So this diagram is just a timeline in terms of what are the different events that signifies that happen from the European data protection law perspective. All right. A lot of people are still facing challenge in terms of those links. See, if it's not that difficult as well. For example, if I say DPIA, just type DPIA ICO, or if it's a TIA, it's coming from IAPP. If you see the keywords, just type in Google. All you may not know is which institution generally provide these free resources and which are the standard ones. So you would just follow the keyword in the link. That will also be able to help you. So Becker is a law which is specific to the UK. Okay. So Becker is not required from the exam perspective. Becker is privacy and electronic communication regulation. Okay. So we don't need to worry about it. So in Pecker, I think if you're using electronic communication such as email for marketing campaign, Pecker applies. If you're using, yeah, so that is I think, yeah, in that case, it is very similar to e-privacy directive. All right. Is e-commerce directive applies on e-commerce entity or both or only GDPR? I think as I told you, when it comes to the lex specialis and lex generalis rule, you have to look at if e-commerce directive will specifically apply to the requirements which is mentioned in directive. I think it applies for both personal data and non-personal data as well. So if there is a scope which specifically addresses personal data, then e-commerce directive will supersede the requirements, right? So we have to look into the depth of e-commerce directive. As I told you, I honestly have not worked specifically to the e-commerce directive, and you don't need to go to the depth. As I told you, all of them are separate subject on their own, right? From the exam perspective, if you go to this depth, you will definitely you don't need to go this much, right? Why do they examine this history? Yeah, not required. Soft opt-in is again something is considered as if you are part of a processing activity, right? And if you are into that process, so people accept that you have given a soft opt-in. Okay, it's something which even in e-privacy directive, based on certain channels, you get soft opt-in. It's like a temporary permission to send a marketing email. So initially they will send you a direct marketing email with whatever context of, for example, you are opted for, you inquired about something. Basis that they send a direct marketing email, and in the first response, if you say that if you are not happy with receiving such communication, you can obviously reject. So it's a temporary permission only, and so that is something you need to consider when it comes to the UK specific GDPR. All right. We are using publicly available communication network, but we are not using personal data in the communication. Will it subject e-privacy directive? Answer is yes, because e-privacy directive is for both personal data and non-personal data as well. Okay, but the material scope of uh, uh, e-privacy directive and GDPR has a common touch points, which is the cookie, because it's a personal data and it has been transferred under publicly available communication network. At the same time, cookies are also considered as considered under the definition of personal data, right? So, but e-privacy directive is for both personal data as well as non-personal data as well. All right. So this is the last content which we were supposed to discuss yesterday, which is in terms of cloud computing, how far GDPR understanding can help assist understanding the privacy regulation around the world. Actually, that has been my selling point for a very long time. I've been saying this for all my candidates that if you have a strong understanding of one data privacy law, and it will help you to understand any other data privacy law around the world. The reason is the 70% of the core crux of any data privacy law remains the same. If you see the history of how these laws have arrived, you see there is a lot of element which is getting repeated and it is getting resonated from the very beginning, right? If you remember the 1980 OECD guideline, the principles are always the same. From 80 to 2023, we will see the principles almost the same. So the crux is remaining the same. What you need to look at is based on the law of the land, culture of the people, technology advancements. There are few changes which gonna come from the latest laws. But if you know one law in detail, understand how to interpret the requirement of the clauses, then it's just a matter of how do you apply that understanding to any other law. So if you study that from a GDPR, which is considered as the most strictest and gold standard when it comes to data privacy law, it makes your life easy to interpret any other data privacy law. Mr. Dattatreya, I hope that answers your question. Can you give an example was opt-in versus opt-out in the scope of direct marketing activities? So opt-in consent versus opt-out consent in general, you should first understand. So opt-in consent is I take a specific action. For example, I tick a checkbox, I say yes over email, or I say yes over a telephone call. This is called opt-in consent. Opt-out consent means there is a pre-tick box. I need to go and remove the checkbox, right? That is called opt-out. Or you receive an email, you go and click on unsubscribe. So that is called opt-out. So when it comes to direct marketing, GDPR, we clearly say opt-in consent is what is required. You shouldn't be following opt-out consent. So which means for the very first communication you need to send, you need to clearly have a valid consent, and every single opportunity you do a direct communication, direct marketing, you need to provide that option for the user to opt out, because it falls under legitimate interest, and it can always be challenged by the data subject under right to object, right? So opt-in consent, I hope it's clear with you. Like the user should have subscribed with a valid action. It also is based on the consent attributes which you would have discussed earlier. A clear affirmative action is what constitutes a opt-in consent. I hope that answers your question, Chai. So we are moving into the last topic. I'm not going to go into the depth of this. So especially when it comes to cloud computing, we should be very absolutely clear, because cloud computing triggers a lot of important elements of data privacy laws. One, we're going to do international data transfer. Second, your sensitive personal data, PII, a lot of things are going to move out of your on-prem to another environment, which you need to be absolutely sure how the information is going to be protected. And third, you need to be sure in terms of the access control, data sovereignty, and you also need to know how the data will be disposed or deleted securely at the end of contract, right? So when you go to this cloud computing, the role of data protection consultant is very, very important. You need to work along with the legal team to ensure the requirements. For example, selecting a cloud computing vendor itself is an important due diligence activity, because cloud vendors are data processors, and as a data processor, they are working on an instruction, right? So they shouldn't be taking any decision on their own when it comes to retention period or sharing with another entity without your permission. So that is where that international data transfer impact assessment will also kick in, because where the data is getting stored is a very important factor. If it is stored in a country where the country has certain specific laws that allows powers, unprecedented powers to the local authorities or special law enforcement agencies, that they can go to a data center, open the server, and collect this information, right? So we need to look at those aspects when it comes to cloud computing vendors as well. And also in terms of how the data will be encrypted, how the data will be destroyed, disposed at the end of the cloud computing contract, and other important elements which you need to take care. Cookies and IPs are again very detailed topics which are discussed in other chapters as not in the workshop, but we would ideally discuss them part of my course. So cookies uh, are considered personal data outright, and IP addresses are considered, especially dynamic IPs are also considered as personal data if it's been processed by the ISPs, because they have the ability to even decipher a dynamic IP. So this also came via one of the court judgments. And search engines, when it comes to search engines, again, a lot of personal data is getting transacted. Who plays what role is again a very important exam topic. Social networking services, the social networking sites like Facebook or any other social networking sites, you need to be completely aware in terms of what role it happens. So as a data subject, whatever information you post on your Facebook comes under material scope exemption, which is your domestic use. The moment you start sharing unknown person's data in Facebook, right? And you have an intent, maybe it's not even commercial, but you are having an intent to spread this message, right? You may be considered as a data controller in that context. So you need to be extremely careful whenever you're forwarding or transmitting certain information about a person who's not even in Facebook, or look at how much you have domestic exemption clause applicable to you. Domestic exemption is very clear. If you share your friends, family, close circle personal data, then you can apply your domestic exemption under GDPR. The moment you cross that boundary, then you will be considered as a data controller for such cases, right? So you should be absolutely aware about these elements. And the company like Facebook always be the controllers, and advertisement companies, whichever come into this Facebook may come will come into the role of joint controllers. So again, who plays what role into of these elements, again, very, very important. When it comes to IoT, again, IoT is a new growing area providing a privacy notice through IoT is a very important element. How do we provide notice in a Internet of Things? You need to also look at some innovative and technology-based solutions. For example, providing a QR code, and we make people to scan the privacy notice because we are using smartwatch, smart car. Everything is getting smart. So much of information is getting collected. So all of them will trigger GDPR. How do we actually handle the elements of your privacy notice before collecting the personal information? How do we give that information of how do we process this data, right? So like the drone, the Internet of Things, we need to look at some innovative ways of how do we provide a privacy notice, how do we make the data subject understand about the collection of personal data and then collect their consent or other lawful basis, right? So these are some of the elements which will be discussed part of this particular topic. Okay. In phishing mails, it is dangerous to click on the opt out because it confirms your mail address. Yeah, that's a good use case. All right. I'm going to cover some of the data privacy interview questions. Many of you look very experienced, but someone is joining for the first time. I'll share these questions which you can prepare yourself. What is difference between privacy and information security? That's a very first topic which we discuss in our day one of workshop. So privacy, data privacy and information security are two different domains. Data privacy stems from human right and information stems from protection of organization information, right? So information security is never worried about what data comes into an organization. The role starts, how do you protect the moment it comes into your organization? But data privacy question, why are you collecting this data? Do you have a purpose to collect it? How you're gonna ensure the rights of a data subject? All these things are some of the important concerns of data privacy. What's the difference between personal data, sensitive personal data, PII? A very common question. So we did discuss about the definition of personal data, and there are special categories data which like your gender, your health data, and you have your genetic data, your biometric data. All of these falls under your sensitive personal data. PII is any data, any personal data that can uniquely identify a person will become a PII. What is different between anonymization and pseudonymization? So anonymization is, for example, you have a customer relationship database, and so the CRM database, if you want to ensure that database can never be related to one particular person, that is anonymization. So how do we do it? We remove all the PII, and we also apply a lot of treatment on the database and to ensure that the data can never be reconstructed and it can be related to one particular person. What is pseudonymization in that case? Pseudonymization is removing the personal identifiers and keeping and segregating in another separate database, so that the data can always be reconstructed, but the data is used for internal purposes. For example, you're sharing the same database for an analytics purpose, so there you don't need the PIA information, right? So that is why we use pseudonymization. What is different between regulation and directive? I think I discussed this in today's session only. What are the GDPR rights that are available to data subject? I think we discussed this. What there are seven data subject rights which are available to in the GDPR: right to information, right to rectify, uh, uh, and right to erasure, right to object, right to restrict, right against automated decision making, right? Did I cover everything? Hopefully. And I'm not a big fan of memorizing things, but yeah. So do all companies have to designate a data protection officer? Answer is no. If you fall into the three important triggers which is mentioned in GDPR, then only you need to designate a DPO. Mr. Dattatare, I've asked this question multiple times. I have answered that question. So the three triggers, if I remember it correctly, if you core operating uh, if your work your organization core process is about large processing of personal data or sensitive personal data, or do you monitor publicly accessible places, then all these things might trigger for you to appoint a DPO, or if you're a public body, right? So what are the categories of GDPR violation attracts maximum penalty? If you remember in the previous session, I gave you four important. Whatever disturbs the core element of GDPR, which is your principles, lawful basis, data subject rights, international data transfers, and finally, if there is a requirement by the supervisory authority, and if you're not fulfilling that, it will attract you maximum penalty. What is the time limit for complying with data subject access request? So generally you get 30 calendar days, and for certain special unique cases, you can get 2 more months, 2 more months calendar days extension. So those cases are again on a case-to-case basis when the data is the data request is complex and you need time to respond to it. So you need to justify why you need more time. And what is the time limit for informing the authorities of a data breach? 72 hours. And what condition the data subject needs to be informed? So whenever there is a risk to the rights and freedom of data subjects, you need to inform the supervisory authority. Whenever there is a high risk to the rights and freedom of data subject, you need to inform the data subject as well. But what constitutes risk and what constitutes high risk, you need to determine as an organization by doing a breach impact assessment. And so the documentation is very important before you reach out to the supervisory authority. They will question you a lot on your decision making, and finally they will see what steps you have taken to mitigate or contain the breach. All right. What are the available international data transfer instruments? So we have three important category. The first category is your adequacy decision. Second category is your security safeguards. Under security safeguards, you have binding corporate rules. You have SEC, which is standard contractual clauses. You have adequacy ad hoc contracts. You have adequacy decisions. Sorry, not adequacy. I'm really sorry. Ad hoc contracts. You have certification mechanisms, and you also have some international treaties under your security safeguards. And finally, exemptions. Exemptions are we call it as derogations. So derogations, it may be from explicit consent or for a contract or for a valid legitimate interest, but the exemption should be extremely narrowly interpreted when it comes to international data transfers. What type of data lies beyond the scope of GDPR? So any organizational data or non-personal data is outside the scope of GDPR. What is layered data privacy notice? So it's one of the approach to make the data privacy notice more readable, and people are able to understand the intent of a privacy notice. So you keep the main important crux, which is like the purpose of processing and the key point of contacts, which is the information about the controller and processor in the first layer, and the second layer subsequently go into the details, and third layer you provide links for specific section for the user to understand the core of the entire notice. All right. So these are some of the important questions which I feel to share with you in terms of interview questions. I hope